Welcome to another episode of Unraveling Intellectual Property with Michael Stein. Today we have our one of our esteemed interns, Nicole Maxwell, who I interviewed before. Today we're going to do a little spin or a little twist on the theme here, and Nicole's going to interview me. I'm excited to hear what the topic is and what the questions will be. So, Nicole, the floor is yours.
All right. So I'm gonna be asking you about someone who may be interested or maybe is going through the process of applying for a trademark. So first, can you give a brief overview of each filing basis for a trademark application?
There are, first of all, you have to figure out whether you're just going to file a word mark or whether you're going to file a mark either stylized or with a logo. And after that determination, you need to qualify for one of four bases. One is what is commonly known as 1A, which is you have actual use. It's possible that once you start using the mark, you get common law rights, but to actually get the trademark registration, the first basis is showing actual use, and you'll have to put the dates of first use and the dates of first use in interstate commerce. The second one is intent to use. And there, you haven't started using the mark. You don't have a date of first use, but you have to, and the trademark office doesn't really question this. They just assume that if you say you have an intent to use, and the intent to use has to be within a span of about 3 years. You can't just say, well, someday I will do that. The third basis is what they call 44D, which is you're claiming priority to a foreign application. So if you filed in Japan, let's say you filed in China, you have 6 months in which to file in the United States and claim priority to that application. So the effective filing date is the date of the foreign application. And the fourth one is 44E, where you're basing it upon a foreign registration. And 44E is the only one where you do not have to have actual use as long as it's based on a foreign registration.
Okay, interesting. So you mentioned that anyone can file an intent to use application. From my understanding, there has to be a bona fide intent. Is there any way to prove that, or is there anything that examiners may look at for the intent to use, or would that be once they're attempting to convert to use in commerce?
The trademark office, when you say bona fide, just means a real, and I forget what I'm not even sure what language it comes from, but the trademark office, at least in my experience, has never questioned. They don't know that, and it's not part of their job to go into your records or into your mind. I mean, if you are an applicant, I would put something in writing, whether it's a business plan or whatever, that we are going to be using the mark, or we're considering. I mean, even if you're not 100% certain, as long as there is an intention to use the mark. So getting back to your initial question, the trademark office isn't going to inquire about that. Okay. And generally the theory is it's the period of time has been over 3 years and you still don't have use, then you either have to reapply or give up going for the mark.
Okay, so if there was an applicant who filed for intent to use and then they actually started using their mark in commerce, how would an applicant prove that they started using it in commerce? And are there factors that they consider to make sure that there's goods and services have actually been used?
Well, the mark in use has to be identical or extremely similar to the drawing that you file with the application. If it's just a word, then it could be any variation of the word. If it's a logo, then it has to look just like the logo. And you have to basically show that the mark either appears on the box, the product itself, packaging. The trademark office isn't going to question whether you've actually shipped the boxes or not. If there's any question, that would be up to a third party to file an opposition or a cancellation and say you don't have actual use of the mark. And therefore, it's the assumption goes with the applicant. As far as what are good specimens, they differ a little bit from goods and service, goods and the services. For the goods, you either have to show, as I mentioned, the mark on the packaging, the box itself, or the good itself. But also, if you have a web page which shows how you can order the mark, and the mark is used on the web page to purchase it, merely advertising materials or bills of sale aren't good enough. You have to show the ability to make the sale. For services, it tends to be more lenient. You don't necessarily have to show where you purchase it, but you do have to show that the services are available through this provider and used in conjunction with the services.
Okay, so if an applicant were to provide a specimen with any of the things you listed, then their application could potentially be converted from intent to use to a use in commerce.
Right. You file what they call a statement of use. You request the conversion from a 1B basis to a 1A basis. And generally, you only have to show for a specimen one good or service for each class, but the trademark office does have the right to request an audit and to show, then the applicant will have to show that you have use in each of the goods in or the services in a particular class.
Okay, great. Hopefully those tips and knowledge will help someone, whether they're filing an intent to use or want to prove a use in commerce application.
Well, I hope that it is helpful, and thank you, Nicole, and for those insightful questions. And thank you all for tuning into another episode of Unraveling Intellectual Property with Michael Stein. I look forward to seeing you on our next episode of this podcast, and take care.